A motion in limine is a legal request made before a trial to exclude or limit certain evidence or arguments during a trial. The phrase in limine means at the threshold, and it's a way for attorneys to address potential evidentiary issues before they arise at trial. Let's go back to April 9th for motion number 2, defense's motion. Limit 404B evidence. Video of Bryan's traffic stop from August 21st, 2022.
All right. Let's take up 404.
Good morning, Your Honor.
That's all.
Your Honor, as it relates to the unnoticed 404B evidence, I understand what's been the discussion on similar verbiage and concerns earlier. However, one of the things that I think it's important to note about this is that although the state has agreed that they will comply with the rule, what we do have so far in self-authenticating records, it's our position is already two mislabels of the evidence. And the specific examples are that technically the DeSales paper, the way that the state wants to use that, would fall under 404B as other act evidence. It's a 2020.
It's a bad act?
It's the rule says other acts to show knowledge or plan. And so the state has expressed that they plan to use that paper.
That's how you can use it. It's,
I'm sorry, I can't hear you.
That's how you can use it under 404. The way you can't use it is a prior term of colloquial term is a prior bad act to show that the party acted in conformity with that they have propensity to commit bad acts. For example, as it relates to the traffic stop, I suppose the concern is, well, he committed a bad act of not wearing a seatbelt or following too closely, and therefore he's likely to commit murder. I mean, that's how the rule works. I'm confused about your statement about the prior academic paper, how that would possibly fall within 404.
Well, when in the self-authenticating pleading that the state filed about the DeSales document, they indicated that that shows that he has knowledge of cleaning up a crime scene. So our position is that we don't want to make sure that there's not some sort of in-run. The same example that I will give you has to do with the Amazon records.
I don't think that we're reading the rule the same is the concern I have, and so I want to make sure I understand your position. Because what you're saying is the state's trying to use evidence to show the defendant had knowledge of how to sanitize a crime scene effectively. And that's one way that you can use evidence of a prior bad act that might otherwise be concerning in terms of propensity evidence. 404B doesn't exclude evidence of plan, knowledge, intent, et cetera, that's not anchored to a bad act. And so I don't see how 404 relates at all to the DeSales paper.
Well, it's our position that the way that the state is putting this in is, in essence, trying to anchor it to a bad act without giving notice of that.
Well, I just don't think your understanding of the rules comports with my understanding of the rule.
All right, well, I appreciate that we have a misunderstanding of the rule. Nonetheless, that's my position. And another example of that is the Amazon records, where they're claiming that those are self-authenticating relating to purchases. And that also has not been noticed.
But it's not a bad act to purchase things on Amazon.
But the state is using it, Judge, to show, using it as other things to show a plan or knowledge or intent.
But that is not what 404 precludes. 404 precludes a bad act, a prior criminal act, a prior, the best term is bad, something that would suggest that it is in your character to commit a bad act, to commit the crime because you've committed another bad act, right? You abused your significant other on one occasion, and therefore you have a propensity to abuse a significant other on a later occasion. That's 404B. Evidence that somebody has knowledge or has a plan not anchored to a prior bad act isn't covered by 404. It's not precluded by 404.
It's our position that the state is trying to do an in-run on that with this evidence. And that's why we raise the issue of 404B, anything that's unnoticed, not coming in as a bad act. One of the ways that we contemplated drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But because we didn't know what they would raise, we raised it in this form, which is without notice, they should not be able to argue evidence is a prior bad act or make any attempt at an in-run on that rule.
So I'm not understanding what you mean by an in-run on that rule in this context.
By saying that the argument about the Amazon purchase is that that was prior to November 13th,
Right.
2022, for the purpose of making a plan. And that's the argument that the state will make about that.
I mean, I think I understand what you're saying. I just think we're
So I think,
completely missing
Okay.
each other's understanding of the rules of evidence.
well, I still stand by my position that the state should not be able to in-run that, and I'm hearing the state say that they have no intention of doing that.
Well, I'll hear what they intend to do in terms, because I think that your reading of the rule puts requirements on them that doesn't exist under the rules of evidence, but I will listen to their
Okay.
response.
Do you want me to go to the 404B on the video or keep it
On the
separate?
video of the traffic stop.
Okay. First of all, there's a pleading that was submitted to the court yesterday, and I have 3 copies of the video marked as Defendant's Exhibit D1 that I'll provide to the court for your review at your convenience. One for the court, one for you, one for Ms. McLaughlin. It occurred to me that it would be much easier for you to determine what you thought about this video if you actually got to see it in full. We don't need to play it in court. You can review that at your convenience. It's not our position that the traffic stop equates to a crime that makes someone capable of murder. It's our position that the traffic stop video brings in other acts that the state is trying to end run on. And I want to give you examples. In this video, things that make it more prejudicial than probative are that it provides presence in Moscow. It is at night. It is a visual of the car that is not just the make and model. It is Mr. Kohberger's statement that he doesn't think state seatbelts provide much in the way of safety. Mr. Kohberger's question about why they need his phone number. Mr. Kohberger's question about how the officer reacts when people lie to him about wearing a seatbelt. If the court allows this evidence in, the state has the ability to use this to make many other points beyond identity. And the jury would have the ability to potentially seek to ask to rewatch the video and draw other conclusions that we are worried about, such as I mentioned, him being at night, not wanting to, it being at night, him not wanting to give his phone number, which could be construed as he wants to hide his identity.
Date of this traffic stop?
Pardon?
Remind me of the date of the traffic stop.
It is on August 21st. So it's
What year?
of 2022. So it's remote. It's
Before the murders.
yes, before. It's clear video of the car as opposed to the videos that are used at 1122 King Road.
Why is that a problem?
Because I think that the state, again, can use this video as an example of where you can see a white sedan clearer then you can see it on 1122 King Road in those videos.
Why is that a problem?
Because there's an argument, the argument could be made that the cars look similar.
Isn't that the whole point of it?
Exactly, and so it's different.
The point of it being, as I understand it, is to show that the defendant owned a white, well, I can't remember the name, the maker.
Hyundai
Elantra, and that he, as opposed to others, drove that vehicle.
Correct, Judge. And so when this video comes in, it's much more than a witness saying, you know, I looked at registration records, and registration indicated that he owned a Hyundai Elantra. When you see it on a video, and then there's going to be other videos that are put into evidence, there's a different argument to be made as opposed to someone verbally reporting a make and model. The state has,
Sounds like that makes the evidence of, I guess I'm just not tracking again under 404 how that particular issue. Now, there may be the ability to cross-examine the FBI specialists about, well, this video is grainy, how can you make this determination of what the automobile is, et cetera, to me is different than, okay, that's what their conclusion is, which you can attack. The evidence that he has a white Elantra within the years and that he drives it, it's prejudicial in the sense that it doesn't help your case, but I don't see how it's unfairly prejudicial, which is kind of what you were talking about, which is 403. I haven't heard anything that's 404, but.
Okay, well, they've noticed it as 404B evidence, so I'm arguing it in that context and what other things can be drawn from this video that make it overly prejudicial. The other thing is that the state's expert disclosure by Special Agent Nick Balance lists August 21st as one of the dates that they claim that Mr. Kohberger is near the 1122 King Road residence. And so the date of this traffic stop is relevant to the state for that, their ability to argue that. That also makes it overly prejudicial.
It makes it relevant. It doesn't make it necessarily overly prejudicial.
Judge, the combination of these things is that this video has the ability to be much more than what the state is claiming. The state is claiming that it proves who he is, what his phone number is, and the type of car that he was driving. It's our position that when you watch the video, there are other arguments to be made that make it more prejudicial and therefore excluded when there are a myriad of other ways that the state can prove his identity,
You don't get
his
to,
phone
and I don't
number.
get to tell the state how to try their case unless they're violating the rules of evidence.
Of course, I don't get to tell the state how to try their case, but I do get to tell this court what our position is regarding that evidence, and when we think that evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do. And that's the point of this argument. We ask that you exclude this video, which I will ask that it be, that the marshal provide that to you, and that the state use a different method of proving identity.
Thank you.
Now let's listen to the state's response for this 404B evidence regarding Bryan's traffic stop video from August 21st, 2022.
I think after what we just heard, we can cut to the chase. The defendant doesn't seem to understand what the balancing test under Rule 403 is. There's no question that the video with the evidence, the defendant's admission of his identity, with his admission and the evidence showing it was his car, the description of the car, the registration of the car, his address, his telephone number, That's all incriminating evidence. That's why the state is offering it. The defendant doesn't like the fact that it's incriminating, but that's not a basis to exclude it. Under Rule 403, in order to exclude relevant evidence such as that, the defendant has to be able to demonstrate to the court's satisfaction that the relevance evidence, that its probative value is substantially outweighed by a danger of unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Just because it's prejudicial, and just because the defendant doesn't like the fact that we can prove who he is, that we can prove what car he's driving, that we can prove what his phone number is, that we can prove his address. I mean, those are all things that tie together to connect the defendant to the homicides. Just because they don't like that isn't a basis to object to it. And so, Your Honor, we would ask that the court deny the defendant's objection to the admission of this evidence.
What about the concern within the video, as I understand it? First you have what is a 404 issue, which is a prior bad act, though one I'm sure everybody probably in this courtroom has committed at one time or another, of violating the traffic laws in some way, including by not wearing a seatbelt. And so can you address that part of it, the prior bad act, and how the court should deal with that? And then also I am concerned with the issue raised about the communication between the officer and Mr. Kohberger, for example, his asking why they need his phone number. That could, I think, be unfairly looked at as if he has something to hide, which would be, I think, unfair. And so I am concerned about that.
And I appreciate Your Honor's comment. I think when you review the video, you can put it, the court will be able to put it better into context. The state certainly doesn't intend to argue or suggest that the colloquy or the discussion between Mr. Kohberger and Deputy Duke somehow showed that Mr. Kohberger was a bad criminal type of person. We certainly are not suggesting by any stretch of the imagination, although the defendant alleges it in their response to the state's filing, that the fact that the defendant was apparently speeding without wearing a seatbelt somehow means that he is guilty of murder. I mean, that's a preposterous concept. And the defendant seems to have backpedaled from that before Your Honor just a little bit ago. The state's purpose is to elicit the vehicle and connect the defendant to the vehicle, the description of the vehicle, the defendant's name, of course, his phone number, his address. That's what the state's interest is. And the state, as it views the entirety of the relatively brief traffic encounter, we don't see anything incriminating or making the defendant a bad person out of that. Now, of course, Your Honor will need to see that and decide if its view is different. But we don't see that as being prejudicial. We certainly are not trying to argue some sort of propensity that because he questioned about, why do I need to give you my driver's license, that all of a sudden that makes him a murderer. I mean, that's beyond a stretch of imagination. Does that answer Your Honor's question?
Thank you.
Thank you, Judge.
Now the defense is going to get up and rebut what the state just stated regarding the 404B evidence, the video of Bryan's traffic stop from August 21st, 2022.
Response?
Judge, there is a way to, clean this up with regard to this, and that would be to not allow the jury to see the video, to have the officer who made the stop, testify about the stop, testify about the identification, the make and model of the car, and the phone number. The argument that the defense doesn't like troubling evidence could be said about every single thing that the state wants to proffer in this case. This is a highly circumstantial case. And so every little fact that is circumstantial is going to be relied upon by the state. And so we have to look at a critical eye with everything that's coming in before this jury to see what the cumulative effect is going to be of that. And so it's not that we don't understand that his identity is going to be proven. As I argued, there are a myriad of ways for them to bring in his identity. But to add all the other components that you will see in the video do much more than just prove that he's Bryan Kohberger with a phone number in a Hyundai Elantra. Thank you.
All right, with regard to this motion and the 404 issue in general, the standard for the admission of evidence that falls under 404 is that the court determined that there is a factual basis by which a jury could find more probable than not that the prior act, if you will, occurred, that the prior act is relevant for a purpose other than propensity, such as identity, and that a balancing test under Rule 403 would not otherwise preclude the evidence, i.e. that the unfair prejudice does not substantially outweigh the relevance. When it comes to 404B evidence, and that's how this was noticed and brought to the court's attention, which is the framework that I'm looking at, 404B does not apply to just any prior act. It applies to prior bad acts, other crimes, other wrongs, not other acts of benevolent or of a type that doesn't implicate propensity. And so I don't see the concerns that were outlined by the defense, for example, related to the DeSales paper and things like that, that's a 404 analysis. That's simply a 403 analysis, which is there unfair prejudice or other concerns that substantially outweigh the relevance? And there isn't the same notice requirement for that issue as there is for 404B. And so I don't see this as the examples raised as a quote-unquote end around at all. And so the state does have a notice obligation when it does come to prior bad acts that it may seek to introduce. At this point, they've only identified the one, which is the traffic stop. The Rule 404 requires notice in advance or during trial when the state is aware of the need for it. And so, I don't think we can say that the shot clock has run out on that at this point, but certainly as soon as the state is aware of the likelihood of the need for that, they have that obligation to seek that. And at some point, the prejudice to the defendant in terms of lack of notice will upend the state's ability to use it if not properly noticed. And so as a general matter, the state is required to provide that reasonable notice set forth in 404B. With regard to the traffic stop, the concerns identified by the defense related to, well, let me go through the 404B analysis. It is technically a prior bad act, which is the sort of colloquial terms used by the courts in describing 404B evidence, in that the defendant was stopped for violating traffic laws and ordinances. I think there obviously is evidence by which a jury could conclude that that conduct occurred. The next question is it relevant for a purpose other than that he has a propensity to violate the laws? I think in this case there clearly is a other purpose besides that, which is identity, which is ownership of the automobile that is alleged to be a suspect automobile, and control over that automobile. And so I think there is a relevant purpose for it. And the next question is that relevance substantially outweighed by unfair prejudice? The fact that it is more powerful evidence than perhaps a simple description by somebody of DMV records doesn't make the evidence unfairly prejudicial. It just makes it more effective. And that is not the type of unfair prejudice that the rule contemplates. And I don't, frankly, track the defense's argument with respect to that. And so I think as a general matter, the traffic stop is relevant. It's not I think there is zero danger that the jury will conclude that because he didn't wear a seatbelt or sped, that he therefore has a propensity to commit murder. I just can't imagine any reasonable person coming to such a conclusion. And certainly the jury will be instructed that they may not use that evidence as propensity, may only use it for the relevance of things like identity, ownership, and control. There are concerns that were raised, however, and so while as a concept, I think the video is appropriate under 404, or notwithstanding 404B and 403, I do want the video potentially, I'll look at it, and it may change my mind, but just from the description, I am concerned about some of the interactions with the officer, that was mentioned that, that Mr. Kohberger questioned why the police needed his phone number. That the officer said something about how he views people that don't wear seatbelts. I don't think any of that is relevant. And it does potentially create some unfair, some danger of unfair or unnecessary prejudice. So I think it needs to be redacted to exclude those kinds of things and have the video that shows his vehicle, that he gives the registration, that identifies it as his, that his answer to what, not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see and probably not much else. So I'd like to see that before it's played to the jury, and you can work on redacting that and showing it to counsel, and within the confines of my rulings, they can raise any concerns they have.
Thank you, Judge.